Good morning. Now I am going to delivering two lectures on the Indian Evidence Act 1872. The first one is the Indian Evidence Act 1872. This act actually came into force on 1st September 1872, and this was actually introduced in India by one of the Englishman who was a famous lawyer at the time, Sir Stephen. This Indian Evidence Act applies to both civil as well as criminal proceedings. This act actually supports, it supplements so many legal acts in the India. One of them is Criminal Code Conduct, then the Bankers Book Evidence Act and Stamp Act and Indian Limitation Act. Actually, this Evidence Act deals with the evidence and its admissibility. Actually, evidence is the main point where a court needs to render a decision. Without evidence, there will be no proof. This evidence generally gives the court with information and facts so that convincing the court can accept the particular version of the events. This Indian Evidence Act 1872 is divided in three parts, and it has 11 chapters and it has 167 sections. Particularly part 1 of this Evidence Act deals with the relevance of facts. Part 2 deals with the proof and the various kinds of the evidences, and the third one is with the proof of the production and the effect of evidence. Why there was a need of this Evidence Act? You may come to know this because this is necessary to prove as against any party to the suit. Otherwise, it will be difficult to understand actual case. That's why it is necessary. Let's understand what is evidence. Evidence means all such statements which the court allows or needs to be presented before the court by the witnesses. The Section 5 of the Evidence Act provides the evidence may be of facts in issue or relevant facts. Evidence may be given facts in issue and relevant facts. Evidence may be given in any suit or proceedings to the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. There are 5 rules of evidence. The 5 rules is, one is admissible. Your evidence must be admissible. First thing. Second thing, it should be authentic. Without authenticity, evidence cannot be admitted. Third one, it should be always complete. Evidence should not be incomplete. Otherwise, it will be of no use. Fourth one is, it should be a reliable one. And last one is, it should be believable. Otherwise, it has no importance in the eyes of law. Then the next is the type of evidences. There are 2 types of evidences actually. One is direct evidence and the another one is circumstantial evidence. Direct evidence means it is if some crime is witnessed by the witnesses, then it is called a direct evidence, and the circumstances evidence means the things which lead to give you the information exactly about the crime. That's called the circumstantial evidence. Then there are 5 types of evidences. One is real evidence, second one is documentary evidence, and the third one is demonstrative evidence, fourth one is testimonial evidence, and the last one is digital evidence. First one is real evidence. What is real evidence? Real evidence is any material that was used or present in the crime scene at the time of the crime. Second one, documentary evidence. Here also there may be some more evidences. One is in this is oral evidence. Oral evidence means any witness who gives the statements about a crime before the court. It's called a oral evidence. And when a document is produced before the court in connection with that any crime, then it is called a documentary evidence. And the third one is demonstrative evidence. Demonstrative evidence means some objects or pictures or models or displays which are seen or which are observed at the time of the crime or at the time of the hearing to support the matter. Then fourth one is testimonial evidence. In this testimonial evidence, it is some sort of a statement made under the oath. Like you can say the affidavit, maybe that otherwise in the court itself somebody may see some person and he may point out him that's yes, this is the guy who did the crime at that time. These are some testimonial evidences. And the last one is digital evidence, which is data information for helpful for the investigation, and that is collected or stored or received from any electronics device, which is helpful in dealing with the or making it as an evidence during the judicial proceedings. This was the actually gist of the Indian Evidence Act. Thank you very much.